Good afternoon. This is Samantha Paget with the Florida Restaurant and Lodging Association. We're excited to have you join us this afternoon for this webinar on the data privacy bills going through the Senate and House. Throughout the webinar, if you have any questions, please be sure to submit them through the questions box in the webinar, and we will try to incorporate those throughout the webinar. I have to read a quick disclaimer to our membership. The information provided here is for educational purposes, and FRLA does not warrant or endorse any particular provider. FRLA is prohibited from providing specific legal, financial, or accounting advice, and the information represented here is not intended as such. FRLA encourages businesses to consult qualified, competent advisors in these fields to explore their specific situation. Webinar is being recorded for future use by the association and other industry members. Your participation on the call is deemed to be your consent to the recording. And I'm very excited to welcome our speaker today, Mr. Al Faikali. He's a partner in the Miami office of Shook, Hardy & Bacon, and he founded and he currently chairs the privacy and data security practice. He represents companies to help them proactively and reactively minimize the risks associated with the collection, use, storage, and disposal of personal information. And his expertise in this particular area is so timely and so helpful on this particular piece of legislation. So at this time, I'm going to, I also want to welcome to our panel, Kevin Johnson of Johnson Jackson. Many of you have heard some of his wonderful webinars before on a wide array of issues impacting employers in the state of Florida, and we're happy to have Kevin here as well today. So Al, I will kick it to you, and thank you so much for being with us today.
All right, thanks, Samantha. Pleasure to be here, everybody. Good afternoon, and thank you for joining for this presentation. So I'll cut right to the chase. The reason we're here is to talk about Florida potentially adopting a privacy law that's going to be incredibly burdensome to companies throughout the state. And so the purpose of this presentation is to explain to you a little bit about what those laws are and the impact to your organization. So I guess just to kind of go ahead and get started, there's some pictures and some information about me and Kevin and Samantha, a little bit about what my firm does in this area. So 100% of my law practice is devoted to helping clients comply with privacy and data security questions, from potential data breaches to class action lawsuits that arise from privacy and data security laws and from data breaches, helping companies prepare for data breaches, and then just getting into compliance with all of these different state and federal and now global privacy laws that are out there. When I keep talking about privacy laws, what am I talking about? I'm talking about the laws that govern the collection of personal information. So whether it's customers or employees or other third parties, you're increasingly collecting information about people, and now there are more and more laws on the books out there that govern what you're allowed to do with that information and what you have to tell people about that, about those collection practices. Until now in the United States, we haven't really been that aggressive on the privacy front. I mean, there have been these data breach notification laws that require you to provide notice when there's been a data breach, but there hasn't been a lot by way of allowing a consumer to control what or companies do with their information. The GDPR, which you may have heard of, which is European privacy law, is kind of like the gold standard, if you will, for privacy laws. That law requires that if a consumer says, I want a copy of my information, you got to give it to me. And or they have to ask to delete their information, you have to comply with that request or to correct their information. And what we've seen is the move from GDPR over to the United States. And of course, it started where? In California. California adopted something called the California Consumer Privacy Act, which is currently the most onerous privacy law in the United States. And it places a lot of obligations on companies. So if you hear me refer to the CCPA or the California Consumer Privacy Act, that's what I'm talking about. It's like the GDPR. And so what Florida is now considering is going to be like that, but it's going to be much worse. And I'm going to explain to you why. So first, what I'll do is go through the dueling privacy bill. So there's a bill in the House, HB969, and then there's also a bill in the Senate, that's SB 1734. And the way it would work is, the House and the Senate pass their versions, and then the leadership in the House talks to the leadership in the Senate, and they decide which of these two versions they're going to vote on, and we won't know that for a while. So I'm going to talk to you about some of the compliance burdens after I discuss like what are in these privacy bills, why do you need to care about it. I'll then talk about compliance burdens, meaning what sort of cost would you be looking at if you had to get into compliance with these laws? What are the things you need to do? Then I'm going to talk to you about how what these bills will plan to do will result in what I suspect will be the largest increase in plaintiffs' class action litigation this state has perhaps ever seen. And I'll explain why. And then last, I'll talk to you a little bit about, okay, so if it's this bad, what can we do about it? And what is the likelihood this is going to come to fruition, and the path moving forward? And then of course, we'll need time for some questions. So feel free to just throw the questions into the chat box, use that feature. I will try to stop in between these topics so that if there's questions on a specific topic, I'm happy to answer it then, or we can, wait till the end, and Kevin can certainly stop me at any point, and Samantha to add their insight. And then also if they have any questions on any of these sections, we can certainly address those. So let's start with these two privacy bills that are out there. And we'll start first with HB969. And then I'll tell you a little bit about how the Senate version is differently. But HB969 will kind of be what we start with. So the scope, what would HB969 apply to? I'll tell you that, and then I'll tell you what it does. The bill would apply to any company that makes more than $25 million in annual revenue, any for-profit company. So if you make more than $25 million in annual revenue, this law I'm about to talk to you about applies to you. You don't have to meet number 2 or number 3. Just any one of these is enough. The second way it could apply to you, let's say you make less than 25 million, is if you buy, receive, sell, or share personal information of 50,000 or more Florida residents or devices or households. So if you do that, then the bill also applies to you for that. And then the last one, which is a little bit more rare, is if 50% or more of your global revenue is from selling or sharing personal information about consumers. So assuming that applies to you, listen on. If not, you might not care about the rest of this, to be honest, but you never know. Like if this thing is still in flux and it could change, but these, here's what it would govern. It would govern the collection, the sale, the sharing of personal information. Now, when I say personal information, what am I talking about? I'm talking about any information that relates to a particular consumer or a household, or is reasonably capable of being associated with a particular consumer or household. Now, to date, in Florida, the term personal information has meant sensitive personal information, things like your credit card number, your social security number, your driver's license number, highly sensitive information that, if stolen, could potentially result in identity theft or some sort of fraud. And that's about to change because the definition of personal information is about to get far broader. Here are some examples of what would be considered personal information under HB 969 and the Senate version if it were to come into fruition. So the sensitive information I mentioned, that's all one part of it. But even like the fact that you know that the person is a Mr. or a Mrs., that counts. If you have their email address, so let's say you market to them as a restaurant, you want them to come to your restaurant, you have their email address, that's personal information. Any information that you could gather from their internet browsing activity on your website, that is also considered personal information. A lot of companies now use something called session replay software and cookies and these tools that are used to track what consumers are doing on their website. That is all considered personal information. Now, keep in mind, it does have to be identifiable, meaning you have to be able to tie it to a certain person. So, now an email address, it could be alcycly@shb.com, right? Like that would be enough. That's personal information. You can use that to identify a specific individual. So, geolocation is another example. Professional or employment-related information that you might have about customers or applicants. Now, keep in mind, these laws do treat applicants and employees a little bit differently. And right now, it doesn't look like these laws are going to apply to employee information, at least right out the gate. So you might be okay on that front. But then the big one, inferences drawn about consumer preferences. So for example, if you determine that that Al likes to eat lobster or likes to eat on certain days of the week, and you want to target him with ads, all of those, my preferences, my characteristics, any rewards program I might have with you, all of that is considered personal information. So the point here is the definition of personal information is really broad. And this is important when we talk about what it is that the law requires. So I'm going to go through 2 slides that have a list of all of the things that HB969 requires. Number 1, it requires an online privacy policy. So on your website, you have to provide a notice that says, here is the kind of personal information that we collect, all the different categories of that. You have to say where you get that information from. You have to say who you share it with. And then you have to provide information to people about how, if they want to request a copy of it or delete it, what is the process for them to do all of that. In addition to the online privacy policy, you also have to have what's called a just-in-time privacy notice, which means at the moment you are collecting the personal information, you are giving the person notice that you are collecting their personal information and where they can learn more about that. So for example, if you had them fill out some sort of a survey as they were leaving a restaurant and it required them to put their name on that, then you would have to give them a notice as the time they're filling out that survey. So you can already tell on point number 1 that this is going to be a burdensome law. So point number 2, you have to provide a copy of the personal information to anybody who requests it. So if Al is a customer in your restaurant and Al sends you what's going to be called a verified consumer request, and there's a process for setting that up, then you have to respond, and I think it's either 45 or 60 days, to Al and give him a copy of all of the stuff you have about Al, everything. And so, or immediately you're like, how would I even know where all of that different stuff is, all of his personal information? And that is a big problem with these kinds of laws, is it can be very challenging to figure that out. We'll talk a little bit about the way to do it, but for now, just know that you would have to give Al a copy of his personal information. Then you'd also have to implement something called a retention schedule, which means that you are only allowed to keep Al's stuff for a certain period of time. After the reason why you collected his personal information is no longer needed, then you have to delete it. And certainly no later than 1 year after the last time your consumer had some interaction with your business. So, not only does it mean having the schedule in place, but you got to follow it, right? Which can be really difficult. You've got to know where all the personal information is and then realize that it has to be destroyed within a certain period of time. Next, you have to give Al the right to delete or correct his personal information. So if I say to you, I don't want you to have my personal information anymore, or the personal information you have about it says that I like the color blue. I don't like the color blue, I like the color red. So you have to change that. Now there are exceptions to this right to delete and right to correct. So if you have to keep it for some reason, and or it's consistent, you need to keep it to complete a transaction with the consumer, or for legal reasons, whatever it may be. There are a bunch of exceptions that in some ways kind of swallow the rule, but the general rule is there is this right to delete or to correct. There is also a right to know what personal information is being sold or shared with third parties. So in those privacy policies that I mentioned at the beginning, you have to disclose whether you sell or share personal information with third parties. Now, really important here is when I say sell, I'm not talking about sell as you and I typically know what that word means, meaning typically we think of a sale as I give you something, you pay me money. Sell in this context means I give you something and you give me anything back that would be of value to me. It might even be information that's valuable to me. And where do we see this? We see this a lot when companies use marketing firms, for example, where they share personal information with marketing firms, and in exchange, the marketing firms provide some analysis on the way their customers are behaving and ways to improve their reach out to these different customers. So keep in mind, sell has a very broad definition in these laws. Next, there's a right to opt out. So Al can say to you, share my stuff. So, and then you have to do it. You've got to stop, and so that means having a process in place that you know where all of Al's stuff is, you know all of the stuff that you sell to third parties, and you're able to pull his stuff out of it, right? So you can already see like how onerous this is going to be. There's also an opt-in requirement, so that if you do engage in any of the selling or sharing of personal information, you're not allowed to do it for anybody under the age of 16 unless they consent to it. So the default is you can't do it for anyone under 16. And you know, I think if it's age like 13 to 16, they can provide the kid can provide consent. If it's under that age, then parent has to, or guardian has to provide the consent. Also, you can't discriminate against somebody who exercises any of these rights. Like you can't charge a higher price. You know, there are, again, some exceptions to all of these things that I'm talking about. But, you know, for the most part, you can't treat somebody differently just because they exercise any of these rights. Next, you have to have contracts with any third parties that you share personal information with to make sure that they are abiding by all of these rules that we've talked about, and B, that they are not then sharing the information further. So that's going to require an analysis of who you're sharing the information with, and then getting all these contracts in place and potentially updating or amending existing agreements that are in place. And then lastly, you have to add what's called a do not sell or share my personal information link. So literally those words have to be on your website if you engage in selling or sharing personal information. And so when somebody clicks that button, it takes them to a process by which they can then get their information deleted, or at least begin the process to stop the selling or sharing of their information. And you know, we've seen this in place. All of this stuff, everything you're seeing here has all been in place in California since early last year. And so we've been watching companies try to grapple with this. And for those of you who have been doing business in California, none of this is going to seem that new to you. What's going to seem new to you is when I talk about the private right of action, which is different from California's. So let's talk about some of the exceptions that are built in. So right now, HB969 does not apply to employee personal information, applicants, interns, or volunteers, which is good news because that's probably a lot of the personal information that you collect. It also doesn't apply if you are any kind of a covered entity or business associate. So if HIPAA applies to you, then it doesn't apply in that instance as well. Also, any personal information that may be governed by these laws that you see below, Fair Credit Reporting Act, Gramm-Leach-Bliley if you are a financial institution, Driver's Privacy Protection Act, to the extent that you pull any of that information, maybe for background checks or whatever it may be, that it doesn't apply to that as well. Okay, let me pause there for a second, see if there's any questions about what HB969 requires, and then we'll talk about the burdens, the compliance burdens, and the private right of action. Any questions so far? No.
Al, quick question here.
Oh, yeah, go ahead, Kevin. Yeah.
It mentions credit card numbers as being part of personal information. Does the collection of credit card numbers in purchase transactions mean you're collecting personal information?
If you are collecting anything regarding a purchase transaction, then and it's identifiable to an individual, a specific individual, then yes, that's considered personal information. Absolutely.
So if I'm just conducting business ordinarily and someone buys a meal using a credit card, and a record of that is created in my transaction history showing that cleared with the provider and that the transaction went through, is that collection of information then that could conceivably be something they have the right to know, is how many times they bought a meal using their credit card from me?
Absolutely right. Yep, that's right. Now, look, I mean, technically you would have the payment card industry's data security standards in place, which should be limiting the amount of credit card information you're using, but a lot of companies aren't maybe fully in compliance with those requirements, and there's a little bit more old school, especially if you're a smaller organization where you may have credit card numbers or just have some in paper form for whatever reason that may be. That's all still considered personal information. So it's definitely something that you need to be thinking about, is all that payment card information. Now, if you're using a third-party processor, that helps, right? Because then you're never collecting that personal information in that way, the payment card information. Ideally, that's the reason why you're using the payment card processor, like a Stripe or one of those, so that they are collecting that information. But each business is different, and they'll have to do their own analysis to figure out if that's the case. Okay, so let's talk a little bit about some of the compliance burdens and the private right of action. So under HB 969, there are, how would you get into compliance with this, right? What are the sort of things you would need to do to get into compliance? And here is some of it. Number one, you're probably going to need to incur legal fees to figure out how this law applies to you, because I'm just giving you the super highlights. The House bill is 37 pages long, and the Senate bill is like 22. So it's not, it is a little bit more complex, and you might want to be looking for exceptions that might apply. You got to figure out what your obligations are, and it's kind of complex. So the reality is you're probably going to have to hire lawyers to help figure that out. And those fees, depending on the complexity of what you do and what you collect and the position you're already in, could be anywhere from $50,000 to a couple $100,000. Then you've got to perform a data inventory. A data inventory means that you're figuring out what personal information you're collecting. Like to Kevin's point, you're trying to figure out, okay, I'm collecting information, payment card information, I'm collecting marketing information, here's where I'm getting it from, here's what we do with it, here are the sources, here are the third parties that we share it with. And so you're making an inventory of all of that. And typically companies will hire third parties to perform it because it's just such a burdensome process. And if you do that, you're looking at a minimum of $40,000. And I've seen, quite frankly, I put 120,000 here, but I've seen upwards of $150,000 to perform a data inventory. Then you've got to figure out, okay, the data inventory is just a snapshot in time, but how do I keep this inventory updated? Because I might start collecting new kinds of information, or I might start using the information in different ways. So then you have to purchase systems that will help you track that and keep it in line. And so that can potentially be another $40,000 to $200,000, depending on the kinds of systems you're going to be purchasing and subscribing to do this. Then you've got to think about the consultants who you're going to have to bring in to actually do this, right? Like if I tell you you've got to purchase OneTrust and implement that, you're probably thinking, Al, you just spoke Latin to me. I don't understand what that means or how to do that. And so you've got to bring in these third parties to kind of help you say, okay, here's your solution, here's what you need to do. I'm going to help it work with your systems. And then when you receive a request from consumers, it will help you figure out the answers. It will help you delete information. It will help you update your privacy policy. And that's going to be at least $50,000 to $75,000 just for these consultants to do all of that. Then on top of that, one of the requirements of these laws is that you adopt reasonable security safeguards to protect personal information. And you can't really know whether you've got reasonable security safeguards in place unless you hire a professional to tell you whether your safeguards are reasonable or not and how you can improve them. And that's called a cybersecurity risk assessment. One of those can cost anywhere from $25,000 to $130,000, and you're going to have to do that annually. So, look, this is quite frankly, that's one of the best things your organization can be doing regardless, because you talk about all these ransomware attacks that are out there, business email compromises. This is a really good way to limit the likelihood of that happening. But in any event, it's essentially going to be required under this law. Then you've got cyber insurance, right? So that if you get sued under this law, or if you have a data breach under this law, you need somebody that's going to be able to pay all of the costs that are associated with that. So again, depending on the size of your organization, the cyber insurance policy can be $10,000 to $100,000. Then you've got training. So the law does require that you train your employees, or at least those employees who would be responsible for responding to consumer requests, so that they know what they're doing and so they can advise consumers on all of this. And so you bring in a professional consulting firm, or maybe you purchase some sort of online training for it. That's going to run you anywhere from $20,000 to $75,000. Then you might need to hire staff. Right? Like this all sounds very onerous. You might have to hire one person, maybe even two people, a data privacy officer whoever it may be, to manage all of this. And that can be another $45,000 to $110,000 per year. So grand total, you're looking at minimum $300,000, but you could be well over $1 million. And for most of my clients, they are over $1 million to comply with these requirements, and they're already doing that under the CCPA. And so, it's not like a one-time cost, like, okay, I just got to set that aside and make that happen. No, these are potentially going to be annual costs. Okay, now let's talk a little bit about the private right of action in HB 969. That's a fancy way of saying the ability to sue, right? Like, how does this law create the ability to sue for a violation? So the law says that if personal information, and remember that term is incredibly broad, is subject to a data breach, and the business failed to implement and maintain reasonable security procedures and practices, the consumer can sue for damages in the amount of $100 to $750 per consumer per incident. And look, I've been in litigation, class action litigation with plaintiffs in the privacy space for a long time. I can guarantee you they're not starting with $100. They're all going to ask for $750 per person. And then the consumer can also seek injunctive or declaratory relief. Let me go back to that for a second, because I want to just focus on this data breach, on the private right of action for data breaches, which is, personal information is really broad. And we know how easy it is for companies to suffer data breaches. A data breach means the unauthorized access or theft or disclosure of personal information. It doesn't have to be intentional. It can be, Joanne sends an email that has an attachment spreadsheet with personal information in it and sends it to the wrong person. It could be something really sophisticated that no company would have been able to defend against, like some Chinese cyber attack. If you suffer that and they access personal information, again, you're going to have to send notice under the Florida data breach notification law. And of course, when a consumer receives that notice, they're going to run to a plaintiff's lawyer who's going to help them get these damages, and then it'll be brought as a class action lawsuit. So that's the data breach side. But now under HB 969, because they just recently amended it, consumers can also sue if the business does not delete, correct, or execute any of those opt-outs that I was talking about. So if they make a request to delete and you fail to do it because it falls through the cracks or whatever it may be, or you don't correct it because you think the consumer is wrong or whatever it might be, or you fail to opt the consumer out from mailings, they continue to receive emails after they ask not to receive them, they can sue you for that, $100 to $750 per person. And usually this wouldn't be that concerning to me, because if Al has this happen to him, maybe Al will sue you for $100, but probably not, because no lawyer is going to want to take Al's case if it's just Al. However, the HB 969 also has attorney's fees, which, by the way, are only one way, so only plaintiff can get them and not the defendants. What it says is that, and why is that important? That's important because now, if Joe plaintiff's lawyer is representing Al in his case, Joe plaintiff's lawyer can spend days and days on Al's case, and he's going to be able to get his attorney's fees for it. So representing one person is not that much of a disincentive. So you can see how this is going to really ramp up potential litigation. So some examples of how this might be triggered: if there is a data breach of meal preferences or allergy information that you might store on your consumers, or their general behavior, that's all going to give rise to one of these class action lawsuits. If there's some incorrect statement in a privacy notice, that could give rise to a class action lawsuit. Or if there's just some failure to delete personal information in a backup file, because it's one thing when Al says delete my stuff, you delete it from what you think everywhere you've got it, but in fact there's also backup information that you didn't think about where Al's information may also be, so you'd have to delete all of that too. Now, I've been talking about HB 969. Let me spend, I think it's just one slide on the Senate version, on its bill. Now, it's calling its bill the Florida Privacy Protection Act. I think between the two, this is the more likely one to go into effect, but don't take any solace in that. Like, it's not any better, really, it's still just as bad. So some key differences from HB 969. Most of the requirements are limited to companies that sell or share personal information. There are some exceptions. So companies that collect information may still have to, will still have to have an online privacy policy like the one I told you about earlier, and they will have to adopt reasonable security procedures and practices to protect the information. So that means that, just because you don't sell or share personal information doesn't mean you're out of the woods. You still got to comply with some things. Also, the right to sue is much broader. It is for any violation of the law and for data breaches. And so, I guess with the recent amendment of HB969, that one's also just as broad. But the point here is that you can sue if you violate any part of the law, like, for example, where you sell information but don't let people know, or there's an opt-out and you don't comply, or you don't have a contract in place that's supposed to be in place. All of those can give rise to a lawsuit. And you see the 100 million to 750 million there, and we'll talk about that in a second as to why and how it could be that large. You'll see it's not that crazy that a class action lawsuit in that amount might actually get filed. Again, just like with HB 969, plaintiff's lawyer can recover attorney's fees there. So definitely something to watch. And now I'm about to go into why this bill is a plaintiff's lawyer dream come true. I've only got a few slides left, and then we can open it to any other questions from anyone. But let me pause there before I start this to see if there are any other questions so far, or observations or thoughts.
Al, this is Samantha. I just wanted to ask a question that I had received from a member previously. How does this impact franchisee, franchisor? So if we have a hotel, for example, that is, flying the flag outside of a major hotel chain, but it is actually owned by an LLC, they own one or two properties. Is it going to apply to the LLC, or does it apply to, let's say it's a Hilton or a Marriott, a larger global corporation? How do they decide when those thresholds are met?
Well, the law doesn't make any distinction between a franchisor or franchisee and any other company, and they do actually talk about if you are within common branding of a larger organization, then it does apply to you as the franchisee. Now, I don't know if as part of the franchise agreement, there may be some provisions in there that allocate these obligations for privacy and data security to the franchisee or to the franchisor. Like we have some clients, a fast food restaurant, for example, where their franchise agreement says that the franchisor will provide many of these services for the franchisee. So I would definitely want to look to that agreement to see how who's going to be picking up the tab for a lot of this stuff, right? So,
great, thank you.
Sure, yeah. So let's talk now about what the litigation risks are here with this bill. And I've talked a little bit about some of the examples, but these are not doomsday scenarios. I mean, they may be doomsday, but they're not like pie in the sky. These things are actually happening. We're seeing these kinds of lawsuits get filed in California, for example, where there's already a law that's kind of similar. By the way, I will say the CCPA is not as bad as what Florida is considering, because the CCPA, it limits its private right of action to data breaches of personal information, as that term personal information is defined in California's data breach notification law, which is sensitive personal information. So if you have a breach of social security numbers, driver's license numbers, yes, you can sue for that, but you can't sue for the other personal information, like the fact that you know that Al is a Mr. Or that Al likes blue, the color blue. Florida, you're going to be able to do that, which it boggles my mind. I mean, just to take a step back for a second, this whole thing boggles my mind, because you've got a Republican governor, you've got a Republican Senate, you've got a Republican House, and these bills are flying through all of these committee hearings, getting through with unanimous support, no opposition. I do think there will be some things to watch in the next couple of weeks, but it just seems crazy to me that Florida is going to become like the plaintiff's lawyer's dream and beat out California, right? So anyway, I digress for a second there, back to the kind of these slides here. So some scenarios: there could be a cyber attack that impacts personal information, like, for example, your preference in certain kinds of food, or maybe any allergies that the customers suffer. There could be an employee who sends an email that contains personal information of the wrong person. There could also be a consumer watchdog. We're seeing this a lot. These consumer watchdogs are coming out of the woodwork, and they are testing companies' abilities to respond to consumer requests. And I'll take it even one step further. There are now companies that are selling products to people to test these processes. And what I mean by that is there's a product that I know of you can purchase, and if you purchase this product, it will scan your email, and then based on what it finds in the email, it will send notices to all of the companies that it sees in your email saying, I don't want you to do any more business with me. I'm opting out of all your stuff. Or I want you to delete all of my information. And you, from a consumer, you're handling all this with one push of a button rather than having to go to 20 different companies, right? So that's why it's so valuable, or such a danger, I think, here is that, you've got these companies out there that will do that and are monetizing it. And so think if you're on the receiving end of this, you're getting, 60 to 100 of these requests a week, maybe potentially, depending on the size of your organization, because of the way this technology is moving, allowing consumers to do this in an electronic and really fast and easy way. But, taking that cyber attack, for example, I mean, that can be incredibly problematic, because let's say you've got information for 1 million Florida residents. I mean, there's like 18 million people who live in Florida, but let's just say you've got 1 million. That's how you get to that $100 to $750 million number. There's a data breach of consumer preference information, and it impacts 1 million people. As a plaintiff lawyer, I'm entitled to a minimum of $100 million, potentially up to $750 million. And the reason the plaintiff's lawyers love this bill is because until now, their biggest hurdle they've faced in data breach litigation and privacy litigation is showing any actual harm as a result of the violation. It could be that there's been a data breach of your system, but then the person didn't really suffer any actual harm, no financial harm, no fraud, they just didn't. And so the plaintiffs have had somewhat of a tough time making the case for those, and the cases often get dismissed. What this bill says is, you don't have to worry about that anymore. We are going to assume that you suffered at least $100 to $750 worth of harm. So the biggest hurdle the plaintiffs have had in these lawsuits is being removed. And so, you can just see, I mean, I was watching the hearing in the Senate last week. I think it was last week or early this week. Anyway, sitting next to the senator who is sponsoring this bill, she's a Republican, was the former president of the Trial Lawyers Association of Florida, like the plaintiff's bar, like literally sitting right there, nodding his head with everything that she was saying. It's just kind of bizarre. So to kind of wrap this up, what are we talking about in terms of the path forward? Where are things headed? What's going to happen? So with the House bill, there is one more subcommittee that it has to go through before it can go to the floor. Then when it goes to the floor, meaning everybody in the House then debates it and votes on it, yay or nay. The Senate bill had 2 more committees to go through after its hearing. It went through its first committee hearing, whenever it was, late last week or early this week. But I'm now hearing that it gets to skip committee number 2 and goes straight to committee number 3. If it passes through committee number 3, then it goes again to a floor vote in the Senate. Assuming that this law passes in the Senate and the House, then, as I was saying earlier, leadership will then decide which of the 2 they need to consider as a general vote for what the final law is going to look like. It will then go to the governor for the governor's signature. Now, this is all, when you take a step back, this is all happening, and I don't want to be kind of political about this, but it's just the reality. This is happening because of a general distrust towards tech companies, and a concern that tech companies are the bad guys. And it's also happening, and this is kind of legitimate, right? Like, it's also happening because people feel kind of creeped out with what may be happening to their information. They don't feel like they control it. They don't know what's happening to it, and they're losing control, and they want to get some of that control back. And one could argue that those reasons are kind of good, and you could see why you would want to do that. But as you can see just from this overview, that's not what this bill is fixing. This bill is going, these bills are going well beyond just impacting tech companies. They're impacting any company that makes more than $25 million, which may sound like a lot of money to many people, but for a business to hit 25 million is not that high. And so it's hitting all these other companies, and it's creating this private right of action. Now, what Virginia did with its law is it did two things that I'm hoping Florida will move towards. Number one, it took out the private right of action. That law is just going to be enforced by the Attorney General in Virginia. Number two, it removed that $25 million number. So you just basically have to collect a significant amount of personal information for it to apply to you. I'm hearing rumors that could happen, but this next week or two is going to be key. I mean, I don't even want to say week or two. I want to say this next week is going to decide what these final bills look like. So to the extent you have leverage, right, and I guess that's sort of the final takeaway here, to the extent that you have leverage, any contacts in Tallahassee, you want to make calls to representatives. Senator Bradley is the senator sponsoring the Senate version, and then House Representative Fiona McFarland is the one who's sponsoring the House version. Call them like this week, because if you don't, you're just going to miss the opportunity to provide that feedback. And they're not hearing from a lot of people, to be honest. At least they're not hearing from a lot of people opposing it, because again, the general sense is you're talking about a bill that gives people the right to control their information, and it gives and so they're not. That doesn't really sound that bad, but what makes it bad is this private right of action and the fact that it applies, and the compliance burdens that we've talked about, and that it applies to such small companies. So I'll get off my soapbox there.
I'll also say that there's some misconception that because there are existing laws in California and Virginia, there is even in the staff analysis, they don't attach a cost to the private sector because they say, oh, well, they're already complying in these other states. And so, especially if you're a mid-sized business that could be impacted, we definitely need to hear from you, and they need to hear from you, because they know that the large store, the large companies, so, the Disney Worlds of the world, the Hiltons and the Marriotts, they know that they're impacted, and they assume that they're already complying with what's happening in California and Virginia. But if you are a smaller mid-sized business that falls under those requirements that Al referred to right in the beginning, that's what they need to hear, and that's what they're not hearing right now. And certainly if you do fall under those, definitely contact me. I want to be able to talk about our small and mid-sized members that are impacted.
Yeah, those are great points, Samantha. And that's it. That wraps up sort of my presentation. Happy to take any questions. I have been writing about the developments on my blog. Feel free to visit that, subscribe if you'd like to learn more. I also try to use that blog to write about developments in privacy and data security laws generally. If you think that would be of interest, obviously no cost, just feel free to sign up. And happy to take any questions if anybody has any, and really just appreciate the opportunity.
Al, we've had a question about third-party agreements. If you have a vendor that is selling an app for mobile ordering, do they need to, somehow protect themselves in those contracts or in those agreements?
If you are sharing personal information about consumers with those third-party apps, then yes. Now, if the consumer is directly going to those third-party apps, then that's a different scenario. Like, for example, if I use Uber Eats or I use Grubhub or whoever it may be as a consumer, then that doesn't create any obligation on you to have a contract in place. However, if you share information, personal information about consumers with any third parties, like any mobile apps, then you would have to have in place a contract that says that the mobile app agrees to comply with the requirements of this law, and that they will delete the information when they no longer need it. I mean, there's some standard language, and to be honest, most of those mobile apps should be generally familiar with that from the CCPA,
Okay.
but you're going to have to start building in that language as part of the agreements.
And are there any legislators that are friends on this issue? Any that have responded positively to feedback from the business community?
In watching the hearings, I know that Senator Taddeo, Taddeo, I believe she's from Miami. She offered 2 amendments. She is okay. Yeah, she offered 2 amendments to the Senate version. One of which would have eliminated the private right of action. The second of which would have reduced the scope to eliminate those companies that make less than 25 million. Basically, exactly what I'm saying needs to be done here. Those were both rejected unanimously, but she is somebody who supports that I know is in opposition. There are several others that have expressed concern or hesitance, but they went along and voted to at least move it out, move the bills out of committee. So yeah.
And I asked, we had a participant that asked, for the names of the sponsors again. Again, the Senate sponsor is Senator Jennifer Bradley, Bradley. She's out of Clay County near Jacksonville. And in the House, it's Representative Fiona McFarland, who I believe is from like the Bradenton, Sarasota area.
Yep, that's right. That's right.
And I think I think part of what we need to help them understand is who is really impacted by this. It's not just large companies that have the ability to engage in this very, as Al's explained, very extensive, very expensive compliance measures, but potentially, especially as, our digital presence as companies is growing, you may easily find a mid-sized business that falls under the heading of, those 50,000 individuals or devices or households, that may be a growing area. So I think helping them to understand what the concern is and who may be caught in this net.
Yeah, that's right, Samantha. And from what I've been able to tell from the hearings and what I'm hearing from people tapped in there, is that the sponsors of the legislature seem to think that there's just a magic button that you can press and it all just kind of disappears, or it all goes away and it all falls into place, and there's just technology and you can purchase your way out of it. But it's far more complex than that, as you've seen from the presentation. So for sure, yeah.
Or that the button, that it already exists in these companies and they're just not doing it in Florida. So they just add the button for, that they have in California and Virginia, and they add it to Florida and it's very easy. And of course it's not. So I think this is really an important bill. And again, I think the initial question is to look at the requirements and look at the thresholds and see if they apply to your company or could apply to your company sometime in the near future. And if so, reach out to me, spadgett@frla.org, and let me know that you're impacted. And be talking your company, or reach out to the legislators and let them know that potentially this is something that impacts your business. And I think that, as Al said, could potentially turn the tide.
Yeah, I agree. It's right on that. It's on that fence, and you all can really make a difference here. So for sure.
Well, Al, thank you so much. And Kevin, thank you so much. And we appreciate your time today. And we look forward to continuing to work with you on this issue. And we appreciate the education, the expertise on this very important issue.
My pleasure. Thank you, Samantha. And thank you, Kevin, for the opportunity. And thank you to all of your members who took the time to watch the presentation. Thanks again.
Absolutely. Thank you so much. Have a great day.
You too. Bye-bye.